Good morning. My name is Maurice Crespi. I'm the managing partner of Schindler's Attorneys. We're a co-founder of COBRA. We formed COBRA approximately 40 days ago as a pro bono initiative to assist businesses. We'll take you through the details of how the pro bono system works and how COBRA can assist all of you. I'd like to welcome Printing SA and all the attendees. Thanks so much for being here today, for making the time. I have no doubt that we'll be able to provide some fruitful information. This is a webinar, so as a webinar, please, we ask that you post questions specific to the situation that you may be in. The more interactive this discussion is or becomes, the more interesting it is. We just had a webinar at 10 o'clock. There were quite a few questions, and it became far more interesting than the regular webinars. I mean, if you think about it, we could pre-record a discussion or a lecture on business rescue and just play that. So the idea is that you ask questions. If, however, you feel that there's inappropriate to ask a question or it's too specific, and other attendees won't be interested, set up a Zoom session with COBRA or Teams or what have you, with your team, with your employees, with whoever. Those meetings are pro bono, regardless of whether you hit the means test. We have a means test as to whether you qualify for pro bono assistance. What we're finding is that most businesses at the moment do qualify for pro bono. If you enter into the COBRA ecosystem, which incidentally is designed to avoid business rescue, but if you enter into the COBRA ecosystem and it simply doesn't work, the business rescue practitioners, the experts, sorry, let me mute somebody here. There we go. I've lost my chain of thought now. Yeah, so you come into the ecosystem, and if for whatever reason the business rescue has to be converted into liquidation, that's all covered. The liquidation costs generally cost in the region of between 20 to 50,000 rands, and that's covered by pro bono. It's a high court application, and that is covered. So be mindful of that. There's no reason why to not enter into the COBRA ecosystem. And let me tell you how it works. COBRA is about avoiding business rescue. So you're going to hear a lot about business rescue today. But it sounds paradoxical, but it's about avoiding business rescue. There's no need for business rescue at the moment if you enter into the COBRA environment, simply because creditors are far more forgiving than they previously have been, and most businesses have the same pressure exerted upon them than they are exerting on their debtors. So the stigma is not the same of business rescue. There's only a few circumstances where business rescue is appropriate, which we'll cover today. There's obviously the situation where if you're in financial distress, it may be appropriate. If a creditor is unreasonable and threatens to sue on a debt, then business rescue puts up a shield. It's the moratorium, which again you're going to hear about, and then the negotiation, the disparity in bargaining power, the disparity in the bargaining position changes. So we're joined by panelists. They're from Engaged Business Rescue. I see. I'd like to welcome Mr. Mohammed. Thank you for joining us today. And to my panelists, Ian Fleming of Engaged Business Rescue, Emma, Abisha, Artisha, Dean Wright, and there are more, Tasneem, Peter Gordon. And I'll be chatting quite a bit with Peter Gordon and Ian. They're from Engaged Business Turnaround. So they are the business rescue practitioners that we've been working on for years. Schindler's Attorneys, obviously we do legal work, and we've been assisting them on the legal side. was going to ask Schindler's also to mute any of the panelists that may still be on, obviously other than me, please. Yeah, so Peter, if you can give us, please, give the attendees a broad overview of business rescue so they understand the process, and then we will dive in relation to particular take-homes that we've identified and we believe are very, very important for the attendees to make a note of. Please ask questions. This is key. Questions are key. So please go ahead and post your questions. You can post them anonymously. As I said, it makes the discussion far, far more fruitful. Peter, over to you.
Maurice, thank you for that, and welcome to all the attendees from SA Printing. Difficult time. I'm aware that various, including Caxton's, have closed down all majority of their magazines, so it is a difficult time for the printing industry, that's for sure. What is business rescue all about? It falls under Chapter 6 of the Companies Act. It's obviously driven from a legal point of view by the Companies Act, but importantly, if you're going into rescue, it is essential, absolutely essential, that whoever's handling your rescue for you, and I'll talk about how you do that in a second, you appoint somebody that is practical, who's a business person. There's a lot of practitioners out there who are really good lawyers, really good accountants, etc., who have never really run a business, so don't know what the issues that face in business, and especially in that small to medium type size businesses. You know, make sure your practitioner is a practical person. But yeah, back to Chapter 6. If the company is financially distressed, and we've had a number of these webinars where I posit that, and so does Maurice, that it would be very difficult to find a company at the moment that isn't financially distressed, certainly those that have had no turnover in the last 2 months. Financially distressed is, however, defined in the Act as a company is going to not be able to pay its liabilities as they fall due within the next 6 months, firstly, or in that period it is likely that the liabilities of the company, fairly valued, will exceed the assets of the company, fairly valued. If either of those are present, then the directors have to consider the fact that the company is financially distressed. And in terms of the Companies Act, they've got the alternatives of either going into business rescue, thereby seeking protection, or not. And if it's a not, and I'm sure Maurice, I was cut off there for a minute, so Maurice, I don't know if you covered it, but if not, then the directors have to find a reason why they haven't, and coming into COBRA would be a valid reason. The directors have done something about it. But the intriguing thing in the Act is that if you decide not to go into rescue, you are obligated to advise the creditors that you are financially distressed. However, you've decided not to seek the protection of Chapter 6. And then, you know, what are you doing about it? So, as I said, COBRA would be one of those things. If you decide to go into Chapter 6 full-on business rescue, then the directors vote on it, they discuss it, they decide they're financially distressed. An important take-home here is if you are having these discussions at a board, make sure you do something about it. Because if the company were to ever go into liquidation, heaven forbid, at some stage in the future, and the liquidator discovers, well, he first of all thinks maybe you've been trading recklessly, and he discovers an email, a board minute, an exchange of memos between two of the directors, which declares that the company is financially distressed. That is classed as a declaration of insolvency, and that does put the directors at greater risk of a personal liability towards the company and the creditors. You can only be challenged with reckless trading whilst the company is in liquidation, and an insolvency practitioner has the ability to make that claim. So do be careful of that, what is put down on paper and the discussions. And when I say paper, I'm talking about emails as well. So just be careful of that, what changes hands. However, if the directors have had the discussion, they decide that they are financially distressed, they can't pay their liabilities as they fall due in the next 6 months, then the company can elect, the directors can put it to the vote. You need more than 50% of the directors voting for, and the company is immediately in rescue. What is required is the director's resolution, together with, importantly, a sworn affidavit from the directors or one of the directors chosen to do it, which declares that, first of all, the company is distressed, cannot pay its liabilities, but most importantly, the directors believe that the company can trade out of its current malaise through some time to sort out their affairs, or the fact that there's a new project coming along and hasn't landed just yet. But whatever it is, the directors believe that this company is worth saving. You file that together with a form at SIP-C, and at the point of filing, so the email's been sent off, the company is thereafter in rescue. In the early days, it was believed that you had to wait for SIP-C to come back with a stamped form, but the way the act is worded, filing is sending the email to the unit at SIP-C. Once you're in rescue, you then are obligated, and it's then all time driven. You've got 3 days to appoint a practitioner. The practitioner then has a time period, 10 days, to have a meeting with staff on the one hand and a meeting with creditors. Both those meetings are broadly to explain what business rescue is all about, but is what I'm doing at the moment, what the rights and obligations are of the various parties, and as well as the practitioner can invite the creditors to form a creditor committee. The creditor committee has no legal standing. It's really a communication tool. If you've got 2,000 creditors, it's far easier for the practitioner to communicate via a body of the creditors, who will then send the information on to the creditors at large. It doesn't affect the creditors' rights and obligations. The creditors still have the right to information during the process, have the right to go to court to have the rescue overturned if applicable. So no effect on rights of the creditors. The other thing that the practitioner importantly has to do at the first meeting is say he concurs with the director's view that this business can be rescued. It's an important point, because the practitioner has to thereafter, every time he communicates with the creditors, which he has to do every month if the rescue plan hasn't been finalized or the rescue hasn't completed within 3 months, he's obligated then to do a monthly report to creditors filed at SIP-C as well. And in that report, every time he or she has to state, I firmly believe that this company can be rescued, or importantly, I believe that the rescue is going to end up with a better return to creditors than they would have got in liquidation. Due to that, as practitioners, we'd always do a liquidation calculation ourselves. If it's complicated or sizable, or we believe there's likely to be a challenge, we will get an external independent valuer to do it for us. But obviously, as practitioners, we know how to value businesses. So once you can confirm that the dividend that the creditors will get out of the rescue is greater than they would have got in rescue, not a difficult bar to exceed, you can continue with the rescue. If at any one time the practitioner believes that either this company cannot be rescued, or the dividend that creditors will get will be less than they would have got in liquidation, then he's obligated to put it into liquidation. Once again, important point. You don't have to discuss that with the directors or the shareholders. You approach the courts and you do an application for the liquidation of the company. The practitioner comes in as what is classed as in supervisory control of the board, but essentially he's like the executive chairman. He has the rights to make decisions on behalf of the company, doesn't have to get the directors to agree with him. Important point, Ian, who's on the call today with me as a panelist, will always work with the directors. We have this view that there's no point in going against the directors unless he's been fraud, and I've dealt with a few of those. But if your assumption is that surely the directors would know more about the markets, the suppliers, they've got the relationships, they know how the business works. So surely work with them rather than against. Important point, collaborative rather than acrimonious. The other important point with the practitioner is trust is paramount. You have to garner the trust of the creditors. It's always a bit noisy at first because the creditors don't know you from Adam, and you're standing in front of them saying the company's gone into rescue. You often take a bit of a verbal abuse in that first meeting, but the point is to try and get the creditors on board with you to convince them, and you can merely refer them to the Companies Act, that you are there to act in their interests, not in the interests of the shareholders. Another important point. Unless you're affecting the rights of the shareholders have very little say in the rescue process. You against, but there again, if the directors, they will always be creditors, executive directors. They'll always also be creditors, because at any one time they owed money for their services rendered, so they by default are creditors. So they will have a vote in the plan for any amounts due to them, and a say in the plan, but only to the limit of how much they owed. Remember, it's a vote that takes place on the plan, and it's rand for rand counts for votes. So talking about the plan, the practitioner has to put a plan together, once again laid out in fair detail in the Companies Act as to what's got to be in that plan. But in principle, it's who the company is, a bit of the legal status of the company, a bit what happened, why it went into rescue. Doesn't have to be too extensive. But then most importantly, what the practitioner plans to do. In this section of the plan, the forecasts, the cash flow forecasts become critical. Just in square brackets, it goes without saying that cash is king in a scenario where you're trying to turn around a company. So just the takeaway, I've had a lot of companies, small to medium companies, say, don't worry, I've asked the staff, well, in lockdown, I had to ask the staff to stay at home, but what I've done is I've asked them to take it as leave. That's not a clever thing to do, because asking your staff to use up their leave whilst in lockdown meant that you're still having to pay them. And far better have a negotiation with your staff to take a reduction in salary due. And this is particularly pertinent for the hospitality industry, restaurants, etc., where people just couldn't work. Well, then surely try and get them to take a reduction. I'm sure Maurice will cover that later about how you do that, but it's essential. Hang on to your cash. Assume that if you're assuming that you're going to be up and running by the end of July, add another 2 to 3 months to that, and assume that you're going to be up and running by the end of October. Have you got enough cash to survive until then? Once the plan is drafted with a lot of input and a lot of lobbying behind the scenes to get everybody on board, because you don't want to go to a meeting to vote on it and have the plan voted down. That can be a bit of a disaster. We had one large organization recently where that happened, which was the Studdefords Group, where the practitioner could not get the plan voted through, and Studdefords eventually went into liquidation. You put the plan together, you publish it within time limits, unless extended. Any extension in time requires 50% plus one of the affected parties. Who are the affected parties? Generally your creditors, your staff because they owed money, and the shareholders if they've got loans in there, but not as shareholders, more as lenders. Labor unions, if your staff are unionized, they have a say. So once you've published it to the affected parties, you then call for a meeting, or a couple of meetings, one with staff, one with the creditors. And in that meeting, the practitioner will explain the ramifications of the plan, take the assembled gathering through the plan, and then propose the plan for a vote. Anybody can put forward an amendment to the plan at that meeting. If, and importantly, if the practitioner believes it's a sensible plan and is in the best interests of all creditors, depending on whether they're secured or unsecured, believes that it is a sensible amendment, he can then put the amendment forward for a vote. That vote requires 50% plus one of the creditors attending, either in person or by proxy, to vote in favor of the amendment. You then put forward your amended plan for a vote. And now the important thing here is your plan has to carry 75% of those voting, as I said, by person or proxy. And if you get your 75%, the plan flies, subject to one other criteria, that of the plan, 50% of those that voted have to have been independent of the total that are voting. So if there's 100 voting for and 50% are independent and voted for, then your plan carries. If it's less than 50%, i.e. you're non-independent, so that would be shareholders, directors who have provided money, intercompany accounts who have provided loans into the company, all would be classed as non-independent. They have a diluted vote. So it's often a bit of a juggling act to make sure. You often go to the shareholders and ask them to only vote for part of their their loans, because if they don't, the plan's not going to fly. Now, this is assuming, of course, that everybody's in agreement, but there is that control that an independent creditor has, that you have to, and rightly so, otherwise you'd get shareholders driving a plan through that might not be in the best interests of the creditors. In that case, the practitioner ends up in a classic, what we call a Mexican standoff, where one party is not agreeing and the other party is going to be worse off, and the practitioner then has a plan that's not going to pass. And that's not a good situation to be in. The practitioner can put forward an alternative plan. If he's silent on it, he can ask the creditors to put forward an alternative plan. If both are silent on it, this company is going down the liquidation route. Assuming he gets his plan through, the plan is then almost the Bible of the company. It's essentially a court document. It's been agreed by all the affected parties. Any party that wasn't in the meeting or didn't vote on the plan can't claim afterwards, well, I didn't vote for it, therefore I'm not going to stand by it. All creditors are bound by the terms and conditions of the plan once it's adopted. The practitioner then implements the plan, whatever it's called for, often a compromise with creditors. The practitioner might be trying to trade out of the situation, which means that he's going to trade to a point where he returns a company back to the shareholders, which is now solvent and sustainable. Important point. He can't hand back a company that's still technically insolvent by way of its balance sheet, or is not sustainable. That would be silly to do, because if he were to do that, there's still a threat of creditors taking liquidation action against the company. So now he's got to a point where the company is solvent. He hands it back to the practitioners. Importantly, he has to confirm to SUBC that the plan is substantially implemented. So there might be some loose ends. As long as he makes sure that those in the hands of people who are protecting the interests of creditors, might be the lawyer through a trust account, it might be a body of creditors themselves looking after the general body of creditors, but he sets such structure in place. And that's an important point, because you don't want a practitioner hanging around forever and a day to cross the last T and dot the last I. He can take it out of rescue if 99% of the plan has been implemented. The other way that comes out of rescue, the plan could fail. We said we're going to go down road A, and we end up realizing road A leads to a dead end. And if it fails, then the practitioner has to put it into liquidation. The practitioner doesn't have to only rescue the company to hand back a solvent business. He can do what we call a controlled wind down. So now the practitioner is selling off the assets in the business. We had a lot of questions in the earlier webinar on what the practitioners are likely to do on SAA. But you can sell off the assets in the business as long as you meet that fairly low bar of, am I going to pay out the creditors greater than they would have got in liquidation? And if the answer to that is yes, then he can do a control wind down. Now, a control wind down, all that means is the practitioner is not under pressure to sell off assets under the auctioneer's hammer. He can negotiate with different parties, ideally find a number of parties who are interested in buying the assets of the business, and thereby try and get the best price available for those assets, and obviously thereby beating the liquidation valuation. A rescue will not survive if the practitioner doesn't have the cash to do it. Now, the cash is not only to pay the practitioner his fees, but also to pay the ongoing costs of the business, paying the rent, paying the salaries, paying whatever it is. And if you're continuing to trade, obviously paying suppliers and negotiating with suppliers to keep providing you with hopefully credit facilities, but often on cash on delivery, which now cash is king. Where's that cash going to come from? Well, the first point to remember is when you go into rescue, you've got an absolute moratorium over the claims against the company. Nobody can sue you for payment. So everybody is literally frozen and you don't have to pay them immediately. Well, that immediately gives you the additional working capital that you would have paid in the next 30 to 60 days to use in the rescue. However, it's often not enough. And the practitioner will spend time in negotiation with the banks, the shareholders. It's not a mature industry in South Africa, but there are people who are prepared to provide distressed debt. As you can imagine, those people are growing as we sit here because of the number of rescues that are likely to take place in the next 6 to 18 months. And so there are people that are interested in getting taking up distressed debt. The important point here is the practitioner has access to the assets of the company that are unencumbered. You can't go and encumber an asset further if it's already handed over to security to one of the existing providers of funding. But with that access, and that might be, for example, a second mortgage bond over properties, etc., you can offer security to a provider of what we call PCF, post-commencement finance, and then that person immediately becomes preferred. Anybody put in money into the business after the rescue date is preferred. What does that mean? They have to be paid by the practitioner in terms of the Act. After the practitioner has paid his fees, he's obligated to pay the provider PCF. Thereafter, he pays, in terms of the plan, the remaining creditors. So that's an important point and it has to be that way. Otherwise, who on earth would be providing funding to a company that's already in distress? Well, I'm not going to put my money in there, but if I know I'm preferred and if I can negotiate a reasonable return on my money, then I'm minded to do it. So an important point here, if it's a company that's owner managed and a shareholder is considering putting further personal funds into the business, don't do that before rescue. Rather wait until the company's in rescue, because at least you've got some reassurance you're going to get your money back. Maurice, I've covered most of it other than the labor issues, which I'm sure you'll cover, but I think that's about it.
Yeah, that's brilliant. Thank you for that. For the purposes of today, I think it would be good to get those brain juices flowing. I think what we'll do is we'll deal with 3 companies, South African Airways, Comair and Caxton. Now, all 3 companies are in different situations. Well, the magazine division of Caxton is in distress. Why? Because of innovation, because of technology, because of disruption. Then we have SAA, factually insolvent. Why is SAA factually insolvent? Corruption and reckless trading. And then we have Comair, who are in distress. Why are they in distress? Because of COVID. So the 3 distinct scenarios that I'd ask the attendees to think about for the purpose of questions, but I think we're going to be diving into those companies by way of examples that we'll be using today. So Peter and Ian, just be mindful of that. The 3 scenarios, Caxton's closing down a magazine division, but I think we got to, let's look at that as a company in distress, but due to market conditions as opposed to COVID or corruption. There's another point that I just want to make. It was touched on by Peter, and that's in relation to the directors and their duty to put business rescue to the vote. So the way it works is in terms of section 129 sub 7 of the Companies Act, directors have an obligation to put business rescue to the vote. So you have to put the business rescue to the vote. So if you are financially distressed at the moment, you're obliged to put it to the vote. Then it goes to the vote. It's a simple majority by the directors. Assuming they say no, they have to give reasons. They have to write to creditors, and the company has to write to affected parties, informing them that it went to a vote. The vote went against the resolution or the proposed resolution that the company entered into business rescue, and the reasons why. And obviously those reasons have to be cogent and rational. So COBRA is one of those reasons. We've created an environment to allow you to put business rescue to the vote. So you have that record. The directors have complied with their statutory obligations, which you need to do. And you then say, and you write to your creditors, and you say, I have entered, and we've got a draft notice. We actually have a letter that you put on your letterhead. You send it to the creditors and you say, we've put it to a vote. We've declined to put our business into business rescue because we're in COBRA. It explains what COBRA is about, and then it invites those creditors into COBRA so that they can be afforded, they can get the same access to information, to skills. And, Peter touched on post-commencement finance. We must also bear in mind that COBRA has become a marketplace. So we have countless partners who, in fact, are prepared to provide that finance. So COBRA is not only about business rescue, it's also about trying to assist. We find ourselves in a bit of a social economy. People are discounting rates to assist, and that's what we're finding is happening in the COBRA environment. So please bear that in mind. You need to put it to a vote, and you need to send your creditors and affected parties the reasons as to why. And COBRA is a simple reason. We already have the template. I'm going to move over to Ian in relation to alternatives, statutory alternatives to business rescue. Ian, whilst we're not about business rescue, there is an alternative, and that relates to a compromise. It relates to Section 155 of the Companies Act. And I was wondering if you can take us through that.
Absolutely, Maurice. Thank you, and welcome to Mr. Mohammed and everybody from Printing SA. So what we do as a turnaround firm, so Engaged and Crest are essentially we're a turnaround firm that does business rescue. Obviously, a lot of the work that we do falls under Chapter 6 of the Companies Act, and therefore we are involved in a lot of business rescues. But what we're essentially there to do is to find the best solution that works for the company. Business rescue is not always the best solution. Business rescue gives the company that steel blanket that Peter was referring to earlier, the protection against legal action. But there are various options that exist, and Maurice talked about the compromise, which is one of them as well. So typically we would engage with a company who feel that they're in financial distress. They would tell us what they feel are the reasons for them being in distress. They will normally have in their heads an idea of how they would plan to get out of that situation of financial distress. And we really try to get a good feeling from them as to a good understanding of the nature of the business. As Peter said, this relationship is very important. We're there to work with the company because the board of directors of that company and the key staff of that company will always know more about the intricacies of the company than we will. And they'll have the relationships and that sort of thing. So it's very important to establish that relationship of trust right from the beginning, and open communication and transparency. We always encourage the company to be transparent with us as to, as to everything that they discuss in board meetings that goes through their heads. Peter and I have seen everything in this business. There's nothing that we haven't seen. So, we really encourage companies to tell us everything. So once they've told us everything, we'll look at the financial information, we'll corroborate what they've told us with the financial information, and then we start formulating in our heads an idea of how we're going to rescue this company. Sometimes, if it's a case of minor financial distress, then it's just a case of business as usual, and we'll effect some minor interventions in order to get the company trading properly and to trade out of the situation that it's in. Sometimes then the option exists of doing an informal turnaround. We call it an informal turnaround because we do it outside of business rescue. And this is normally quite possible when you have sort of one key creditor, like a bank, and the company's in default to the bank. So the bank knows about the financial distress of the company, but the other creditors are all getting paid in the normal course of business. Because we, as practitioners, and Peter and I and COBRA as a whole, have got strong relationships with the banks, it's been very easy for us to sit down with the bank and say to them, listen, we're not going to put this into business rescue because of the name, because business rescue is can be seen to tarnish the name of the company, although that's not the case currently because most of our companies are in financial distress. And we'll say to the bank, listen, work with us, we'll put together a turnaround plan. You guys are the major creditor. You're going to have to agree on it. Once we've agreed on the turnaround plan, then we can implement it, working with management, but outside of business rescue. And then the possibility exists of a Section 155 compromise as well. Now, remember, we all, throughout the entire process, we're balancing in our heads, is it business as usual? Do we need to move to business rescue? So we're weighing these things up all in our heads, all the time. Section 155 compromises also falls under Chapter 6 of the Act. It's the last section in Chapter 6. And what it allows us to do is to negotiate a compromise with each class of creditors. So classes of creditors that are classified as per the Insolvency Act, being secured creditors, preferential creditors, and concurrent creditors. In terms of a Section 155 compromise, we need buy-in of each of those classes of creditors, or the class of creditor that is being affected by the compromise. So we would typically sit down and draw up a compromise plan. We then have to call all the creditors together and explain the plan to them, and they will vote, and it requires 75% of the creditors in each class and by value to vote in favor of the plan in order for it to be acceptable. So once we've got agreement from once we've got the votes of the creditors, then we take the plan to court. We get it made an order of court, and then immediately the compromise is in place. Compromise will typically see all classes of creditors taking a haircut, or their balance, the amount owing to them, being reduced as a result of the compromise. So secured creditors, money owing to secured creditors might be reduced by 10%. Money owing to preferential creditors might be reduced by 30%, and the amount owed to concurrent creditors might be reduced by 80%. Whatever, those are just examples. Once it's made an order of court, then those compromises are effective, and the company can carry on trading. Often we'll carry on trading with continuing assistance from us as the turnaround professionals, assisting the company to make sure that they're getting the business right, the operations are coming right, it's translating into cash flow, and so on. One disadvantage of a compromise is that it does not have that legal protection while you're busy negotiating the compromise. So during that time, while you're putting the compromise plan together, you are vulnerable to attack from creditors, either wanting to liquidate the company or to get judgments against the company and attach assets and so on. And then obviously there's the choice of business rescue, which Peter has very eloquently explained to us, and he's gone into a great amount of detail there. Business rescue is from the moment that it's put into business rescue, in the case of a voluntary business rescue, a very simple process to put it into business rescue. As Peter said, it's a director's resolution, it's a sworn affidavit, and it's a few forms. And once you send it to CIPC, the company is in business rescue. Then it enjoys the legal protection against creditors. So yeah, Section 155 compromise doesn't have that from the beginning, but business rescue is very easy to put it into business rescue. Probably 99% of business rescues are voluntary business rescues. In other words, where the board has taken the resolution to put it into business rescue. The other option, as Peter explained, is for a creditor or an affected person to apply to court to have the company put into business rescue, and for their choice of business rescue practitioner to be nominated to be in supervisory control of that company. Typically happens when creditors or shareholders, for example, have lost faith in the board, and they know of a business rescue practitioner who can get involved and manage the company properly and make the decisions that need to be made in order for it to get out of trouble. The fifth option that exists, and it's something we obviously try to steer as clear from as possible, is liquidation. We are not there to liquidate companies. We don't work as liquidators either. There's no incentive for us to put a company into liquidation. But we have had instances where we've done a review of a company, and the company is so rotten to the core that there's been huge, large-scale fraud at director level, and business rescue in those cases is just not a viable alternative, because we want to be able to work with the directors, and we can't work with the directors that defrauded the banks for hundreds of millions of rands and plead innocence. That's just a disaster waiting to happen right from the start, and we just know we'll be probably inundated by a tsunami of litigation as business rescue practitioners, and in those cases we would rather just encourage liquidation. But that doesn't happen often, but yeah, those cases do come up. So Mauricio, those are the alternatives. Those are the options that exist, and that's basically run on how we interact with the company from the beginning.
Great. Yeah, thanks for that, Ian. We do have a question. Our first question is organised labour included in the vote for business rescue? We've seen that the unions, when it comes to SAA, they've been pretty active. They have been making a lot of noise in relation to the suggestion that SAA be liquidated. So I'm going to ask Peter that question, but before I get there, let me just deal with the legal landscape when it comes to employees. And before I get to there, let me deal with contracts, because the following provision doesn't apply to employment contracts, but there's a provision in the Companies Act that where the business rescue practitioner is obliged to send a notice to counterparties to contracts to suspend the contract. So I've said to you that there are a few take-homes. The one take-home, and a very, very important take-home, is that if you have, let's say, a lease agreement and you cannot pay the rental, the business rescue practitioner must immediately send a notice to the landlord suspending the lease. If the landlord does not receive the notice, or is not sent the notice rather, the lease remains in place and the lease can still be cancelled and you can still be evicted. So it's crucial that you get your hands on a business rescue practitioner who knows what he's doing or she's doing with reference to the Act, because we've seen it as Schindlers. We've seen business rescue practitioners not send those notices out and a cancellation taking place, followed by an eviction. So very, very, very important. So I'll move now to employment contracts, and then I'll move over to the question. Employment contracts are not subject to that provision, and the business rescue practitioner cannot just simply send a notice suspending the contract. Employees have the exact same rights that they enjoyed prior to business rescue. Those rights are not diminished. In fact, they have additional rights by virtue of the provisions in the Companies Act dealing with them and affected parties. So where we've all heard, and maybe some of you guys have been able to achieve this, but where we've heard about 25% remissions in salary, let's say, so you reduce about 25% or 50%, you cannot unilaterally impose that on an employee. You need to still go through the Labour Relations Act. And the important provision there is Section 189 of the Labour Relations Act, which deals with retrenchments, deals with dismissals based on operational requirements. And one needs to consult with employees in terms of that section, even if your intention is to not retrench, but to change, let's say, a term such as salary, a reduction in salary. The reason you've got to go through that section and comply with that section is because if an employee does not agree to the remission, then you have to give the employee an option of taking a severance package, and the law is 1 week per completed year of service, or in terms of any policy that you may have. So those procedures remain in place. Another take-home is we're finding, and Ian will deal with this later, but we're finding a lot of businesses are negotiating with their employees. They're complying with the Act, but they're fixing a discount. So they're saying 25% less. But the future is so opaque. We don't know when a vaccine is going to come along. We don't know when a cure is going to come along. So how can you possibly budget for a 25% reduction in your salary bill? Because you simply don't know where this is going. So Ian will take you through it, but what COBRA is doing is we're achieving negotiations with employees where the salary becomes variable. It's rendered variable on the basis that whatever cash comes in gets distributed pro rata to their employees. So they keep their jobs. If there's no cash, unfortunately, they don't get a salary, but they wouldn't get a salary in any event because they wouldn't have a job. Or they get pro rata whatever cash comes in. And that seems to be working really, really well. So please bear that in mind, that if you're going to do it, and incidentally, part of COBRA's pro bono is to meet with the employees and will ensure compliance with Section 189 of the Labour Relations Act. And incidentally, very, very sensitive discussions. The employees generally appreciate the discussions that we have with them. because we approach it on the basis that the more we protect them, the more the business rescue practitioner, the directors, are protected legally from any challenge to an unfair procedure or a substantially unfair dismissal or change in an employment contract. So with reference to SAA, is organized labor included in the vote for business rescue, Peter?
Maurice, yes. The Act specifies these are a group of people defined as the affected persons. Now, affected persons are essentially anybody that's owed money by the company, and it includes the employees individually, if not represented by a union, or if represented by a union, then the union itself. So the practitioner is obligated in terms of the Act to call a meeting with, on the one hand, the creditors of the company, anybody that the company owes money to, and then on the other hand, the employees, and advise the union, or in SAA's case, the unions, because there's a number of them, of the rescue. And at that meeting, it's merely a matter of explaining what business rescue is all about, explaining that if it's to the staff, explaining to them that they allowed to form a committee to communicate with the practitioner. Same with the creditors. The creditors can form a committee. Those committees have no legal standing other than as a communication conduit to enable the practitioner to only communicate with a handful of people rather than, all the employees of SAA in this example. It just makes life a little bit easier. The other thing that the practitioner has to say at that meeting is whether he believes the company can be rescued, as I discussed right at the beginning. Now, that's the first meeting. Once the plan has been put together, the creditors and anybody, it's defined in the Act as anybody else who has a vote in the plan. Now, because the employees at any one time are creditors of the company, each day they work for you, they might, if they're working for you after rescue, they become preferred creditors because they're providing what we call post-commencement finance, which I talked about earlier. They then have a vote, but on a rand for rand basis. So they form body of the creditors at large who are voting on the plan. It could be, it would be unusual, but it could be that the employees then have control of the plan because they carry the majority vote. But they are entitled to be kept up to date with information from the practitioner. They have the rights to attend and be advised of any court action that's going on, as do creditors. So from that point of view, the unions play part in the plan, but it would be an unusual situation where the unions can vote a plan through or not, based on the value. More importantly, though, the unions being there to represent, remember what they're there to do, they're there to represent the employees. So the unions have been known to go to court. The application for the rescue of SA Express was brought about by a creditor, but don't forget that the reason we believe that the government decided, one of the reasons, to put SA into rescue is there was a pending application by Solidarity to put it into rescue. So that was an example of a union exercising their rights as an affected person to go to court. And I think Maurice covered it. The plan in COBRA is exactly as what one would do in a rescue that was outside of COBRA, is communicate and negotiate. If it's with the unions, then so be it. We negotiate through the unions. Unions can be obstructive. Bear in mind they have a far lesser mandate than the practitioner. The practitioner is trying to pay everybody, whereas the unions are there merely to protect their members. So you do have a conflict there that one's got to try and find a middle road to. But generally, I think, look, I'm aware of a case where NUMSA approached the courts to have a practitioner's decision to liquidate the company overturned, and on the basis of trying to save jobs. It came to nothing because by the time a practitioner decides that this company really should be liquidated, surely he or she has been down the road of many discussions with many people to try and see if there is hope. And really, if it's got to the no hope stage, then if it, i.e. it's landed up in liquidation, as Ian said earlier, that really is the end of the road. And if a union's going to court to have it overturned, the chances of its survival, unless the union itself is prepared to fund. Now, remember, the big unions have investment companies as well. NUM's got its investment company, so is NUMSA. So those unions could well invest into the company merely to keep it alive. But I would exercise caution there if I were advising the union, certainly the investment arm of the union, because if your main aim is to save jobs, it might be the very reason, and we know from international data that SAA has the highest staffing complement per miles traveled of any airline in the world, or close to. I'm not sure it's number one, but it's certainly up there in the top 5%. And that's an indication that SAA is currently overstaffed. Now, you can see, I don't have to explain it, the conflict is there. Union trying to keep those jobs alive, the practitioner trying to keep the company alive is an immediate conflict. But that means that communication and the negotiating skills of the practitioner become even more important than in normal situations. I don't know if that answers it, Maurice, but that's the SAA story.
It does, and I was thinking maybe we should use our example. So I'm going to I'll put it on the screen. Just for the audience's benefit, we use an example here. When it comes to the voting on the plan, I'll get to the questions, but when it comes to the voting on the plan, what if a 100% shareholder is owed 1 million rands on a shareholder's loan account, trade creditors 15,000 rands, directors 500,000 rands, and employees 100,000 rands? How would the voting work there? The shareholder comes to you and says, I want the plan to be X, Y, and Z. I couldn't care. I'm owed 1 million rands. Can he vote the plan through? Ida?
Maurice, no. And the reason for that is I discussed earlier, the 75% vote, remember, in person or by proxy. So you have to be there to vote on the plan. If those people are voting, you need 75% positive vote of those that voted, of which 50% of those voting, now important point, because some of them might have voted against it, 50% of those voting have got to be independent, and a shareholder is not classed as independent. So that 15,000 in your example of trade creditors has quite a strong say, it has a very strong say, not quite a strong, very strong say in the voting of the plan. The 500,000 you've got against directors, they are connected, so they fall into the shareholders. So you've got non-independence of 1.5 million. But importantly, employees are not connected because they're there, not because they lend money to the company, but they lent their time to the company and haven't been paid yet. So they would fall into the trade creditors group. So you've got 115,000, and if they agree between the trade creditors and themselves of a different route to take, then they have quite a strong say in the plan. Now, once again, behind the scenes, you lobbying these 4 different parties to make sure that you're putting something forward. But if you've got an aggressive shareholder who says, I couldn't care less about anybody, then my answer to him would be, well, please, can you just give me 115,000 rand, and you can buy off the employees and the trade creditors, and buy off, not in a legal sense, but buy off, I mean, the shareholder would be entitled to go and buy up the claims. So you can buy up the trade creditor games, you can buy up the employees' claims, and then thereby push the plan through. However, here's an important point, because remember, each day that this company is continuing to trade in rescue, those employees are constantly creditors. On the 25th of the month or whenever they paid, they never go down to zero because you've always got accumulated benefits, leave pay, bonuses, etc. So each day of the business rescue, whilst it's in rescue, creditors are increasing their liability, or the company's increasing its liability to the employees until paid. So at any point in time, the employees will always have a say. So now if the shareholder is wanting to do that, and he doesn't want the blocking vote from the employee body, then he's got to put post-commencement financing by way of a loan rather than just buying a claim. And the practitioner can then use that money to pay the staff as you go. But unfortunately, and as Maurice touched on, 2 things. The creditors 99%, no, not 90% of the time in a plan are going to be compromised. And that compromise means they're not going to get the full value of what they owed. And equally, in a large number of cases, the staff count is reduced in a business rescue. Not always, because it might be a matter of selling off divisions. SAA might sell off the practitioner might sell off the division that does aircraft maintenance, which I believe is quite profitable and it's got some fairly good long-term contracts. He might sell that with the entire staff complement. But obviously, selling it means you've got to find a willing buyer. Now, a willing buyer might say, well, hold on a minute, even this division is overstaffed. So Mr. or Mrs. Practitioner, you do me the favor of reducing the staff headcount numbers, and then I'll consider buying it. So there's always a balancing act. I think people are getting a flavor of that you're juggling a whole lot of issues here and trying to suit a potential suitor in buying the business or a potential shareholder to put additional money in. Unfortunately, the practitioners in SAA failed on that front because the shareholder, being the government, refused to put in post-commencement finance. So in those scenarios, it really does become a very difficult juggling act to find out where that money is going to come from. But bottom line is, an example like this, the independent creditors have quite a big say. There are ways around it, but they do have a big say. Maurice, and then also just to say, to remember shareholders, if you don't affect their rights. Now, in this example Maurice has presented to me, the shareholders are also funders. So they're wearing two hats. They're a shareholder and they're a lender to the business, i.e. a creditor. But if they haven't lent money and they're merely shareholders, often the case in a listed company, for example, the shareholders have no say in the plan unless their rights are affected. If their rights are affected, then they have to vote on the plan as well. Separate vote from the creditors, but they have the right to vote on it. But if they haven't been affected, shareholders, and it's an important point, have absolutely no say in the plan. It's a creditor-driven process.
Yeah, thanks for that. So we have some questions. I'm going to be asking Ian to address how is business rescue practitioners' remuneration determined. And then I will be asking Peter after that to deal with Sandrin's question in relation to creditors and the selection process of payment. But before we get there, I'd like to deal with a question that's been posted, which is on what basis is printing SA involved? And it's quite simple. We've been approached as COBRA by a whole host of organizations to assist their members, from the various chambers to, in fact, even a construction company approached us to deal with their suppliers. So it's merely an approach. We provide these services on a pro bono basis. If you know of any organization who would similarly like to have a session like this, we can arrange it. No problem, and on relatively short notice. So be mindful of that. It's about us reaching out and getting to as many businesses as possible to give them pro bono assistance. I mean, I've been at this for the last 40 days virtually full time. We've only been doing, I've personally only been doing pro bono, and there's been a bit of fees that I've built here and there on other matters, but completely unrelated to COBRA. You know, in the last 40 days, I have not billed one COBRA participant for the legal advice that I've been giving, and I've been giving legal advice daily for probably 12 hours a day. So be mindful of that. Ian, can I move over to you?
Certainly, Maurice. Thank you for that. So the question is, how are business rescue practitioners' fees determined? Let me first say from the outset, the way Peter and I have always worked doing business rescue, the way COBRA works, is that the number one criteria when determining fees is what can the company afford. That's the only way, and that's, you know, we all know business rescue does not have a great reputation, and we confront that openly. You know, we're the first ones to say that business rescue's been around since 2011. A lot of the practitioners who have been doing business rescue have not done the industry any favors through the way that they've operated. One of the things that they've done wrong is simply by lumbering a company with costs right in the beginning, charging exorbitant hourly rates and you know, within 3 months, the company's got no more money because they've paid so much money over to the business rescue practitioner, and the company ends up being liquidated. The way we've always worked is that we charge the company based on what the company can afford. And that's a very nice way in which we've differentiated ourselves right from the beginning. Typically, when we get involved in a company, whether it's a small, medium company or a large company, we'll consider what can this company afford. Okay, we'll look at typically putting into business rescue immediately. The company will have and be able to enjoy savings for cash flow savings for almost from the word go, as a result of having long-term debt repayments suspended, and you know, us being able to immediately get in as business rescue practitioners and cut out costs that don't need to be there. So just an example of a small to medium-sized company, we'll be able to get in. We'll immediately be able to save the company monthly cash flows of say 200,000 rand a month. Then if we're charging that company a 50,000 rand a month fee, for example, then obviously our fee has justified itself right from the beginning. So that's the way we've always worked. As Maurice explained, COBRA is has a very large pro bono element. What it comes down to is that we will never let fees stand in the way of a successful business rescue as opposed to liquidation. So to the extent that our fees or professional fees, be that business rescue fees or legal fees, are preventing a company or preventing a business rescue of a company from being successful, we will waive fees to the extent that we need to in order to ensure success. So back to how fees are determined. The Companies Act of 2008 legislates what the fees of a business rescue practitioner are. For a small company, it's typically the Companies Act says 1,250 rand per hour, including VAT. For a large company, 2,500 rand, including VAT. In order to attract competent professionals to the business rescue industry, it's become the norm that for a large company, dealing with a large company, a 2,500 rand an hour fee is probably too little in order to attract the talent that is required to turn that company around successfully. Therefore, the practitioner has the option of saying to the directors from the outset, my fee is X, let's call it 3,000 or 3,500 rand an hour. This is my fee. This is what I will be charging from the outset. The practitioner will reach an agreement with the directors as to what his hourly fee will be, and then then he will have a meeting with the creditors, either right from the outset or at the time that the business rescue plan is being published, and the creditors will be required to approve his fee. So the regular fee, the monthly fee, or the fixed fee that we charge has to be affordable to the company. That is not negotiable. And what we do in order to motivate ourselves, in order to incentivize ourselves and keep ourselves excited, and what most practitioners do is they charge a contingency fee as part of the business rescue plan. Now, the contingency fee is very important. That the contingency fee or success fee is based on real turnaround success. In a small to medium-sized company, at the date that the company comes out of business rescue, the practitioner would then typically be paid a fee of, let's say 4 or 5 times what his monthly fee was, and we'll stagger that according to keep it affordable for the company.
Peter, can you mute your mic? I think you're writing, and it's coming through quite strongly.
Sorry, I thought I was on mute.
It sounds like you're writing, and it's coming through quite strongly. So if you can mute your mic, please.
Okay.
Thanks.
In a larger company, it would be based on milestones. So sort of 3 times throughout the course of the business rescue, when certain milestones of success are achieved, then we would earn a success fee. Very important that the success fee is, if you're talking to other business rescue practitioners, for example, that the success fee is based on real success of the implementation of the business rescue plan. We've seen many examples that we of success fees that we disagree with in principle, whereby the practitioner has, for example, proposed a success fee or charged a success fee that is payable to him on acceptance or on approval and adoption of the business rescue plan. Now, that immediately creates a conflict of interest for the business rescue practitioner, because he has to put together a business rescue plan that is feasible and implementable. Now, if he's getting paid a success fee based on him having that plan approved, then he is more than likely going to be compromised in the extent that he will cave into creditors' demands in order to amend the plan to the extent that it will be approved and adopted by those creditors. So if he's caved into the creditors' demands to get the plan approved, then it's more than likely that the plan will not be implementable. So, having a success fee based on the approval or the adoption of a plan is not a real success fee. We don't believe in it. And it's also not a success fee that's earned in the implementation of the business rescue plan. Maurice, I think that more or less covers fees.
It does. I just received a message. I'm told that we're going to be concluding in 8 minutes. I've got a 1 o'clock meeting, so I'm quite happy to continue until, let's say, 5 to 1. I think the panelists who have to go, they can drop off, but I'll certainly be around. Yeah, so basically what you said in a nutshell, apropos COBRA, is that if a company or a business cannot afford to pay a professional fee for legal advice, for any advice, they will not have to pay. It becomes pro bono. It's a simple. The turnaround takes place at no cost to the company. So that, I think that's very, very important, because there is no gamble in having us try and salvage the company. Because we had limited time, I know there are questions. I'm going to ask Dean, though, to please take us through the various relief funds and how they work, and just give us an idea of what's going on. I know it's a moving target, Dean, so give us an
morning,
update.
everybody, and morning to all the attendees. Thanks for joining us this morning. So I think it's just important to start that part of the pro bono initiative and COBRA in general has been putting together a myriad of resources on these various relief funds and information regarding these relief funds. And the quickest way to access these is if you go to www.cobra.org.za, and if you scroll to the bottom of the page, you'll see there is a link that says a help portal and knowledge base. Once you click on that link, it takes you to a page that contains all of the current relief. And I say current because, as you say, it's a moving target. Things change weekly, daily in respect of the various initiatives. But we, for the most part, are quite up to date. And you'll see there's all the initiatives that are available to various individuals as well as SMMEs that could sort of surround the relief funding or relief measures. And just for the purposes of today, I'd just like to highlight 3 of them that I urge everyone to probably go and have a look at, because it seems like they'll be the most applicable to the audience today. It's very hard to understand, what companies are listening, what the company's makeup is in terms of South African owned, percentage of BE, as well as employees. But the 3 I'd like to highlight, and I urge everyone to go have a look at, is the COVID-19 loan scheme. This is for small and medium enterprises. And that's the first one to have a look at. The second one is the debt relief fund. And the third one is growth and resilience facility. I think those are very applicable to the audience today, and I'd urge everyone to go and have a look. You'll see what we've done is we've got quite a nice snapshot of what the fund or the relief measure is about, as well as where you can register for the relief programs, the websites that you need to have a look at. And if you have any further information that you require, after having a look at those particular initiatives, you're more than welcome to drop us an email at info@cobra.org.za. And another thing that we always forget about, Maurice, is everyone really looks to these relief funds as a helping hand. But what we're finding with all the queries that we're receiving is often the first port of call is to try and attempt to get any type of relief from your banks, be it a payment holiday, call it bonds, it could be in terms of a loan, and that's the first port of call is to negotiate and communicate with your bank at the first instance, and then look at those relief funds. Obviously, you can do those together, but we're finding that there's a lot more of the bank initiatives that are accessible and quickly accessible. Then the relief funds are taking a bit of time at this stage. And I think another one that we also overlook quite a bit is the tax initiatives and the tax relief that is available. Again, the takeaway there is that all these measures in terms of the relief funds as well as the tax one is the corporate governance of your entity has to be up to date, and it has to be pretty solid. So for example, the tax measures, you have to be tax compliant, you have to be in good standing with SARS, and then you're only able to make those, make application for those relief measures. Very similarly to TERS, which is the initiative from the UIF. This deals with you're able as an employer to apply for a percentage of relief on behalf of your employees and all of time, but it works out of the percentage of what the employee's salary is. The employees have to not partially been able to work as a result of COVID. But again, it comes back to the corporate governance. In order for you to make application to this fund, you had to be UIF registered prior to the lockdown. And that is what we're finding is quite a problem. A lot of companies weren't up to date and their governance wasn't where it should be, and they've missed out on those type of relief measures. As a side note, just particularly for the UIF and the TERS, is that if your UIF wasn't up to date but you were registered, we've seen UIF entering into acknowledgements of debts with those companies benefit of the employees. So that's it in a very high level nutshell. Just to touch on that, is in our website, on the COBRA website, if you scroll to the bottom or wherever you on the landing page, you'll see there's a green button on the bottom right, and it says request assistance. And we've worked long and hard on creating an almost Google-like search function. So you can literally put in a phrase that you would like and click search, and the relevant articles and assistant measures will come up. And it's very intuitive and works exceptionally well.
Great, thanks so much for that, Dean. I'm going to ask Peter to deal with two questions in one. The question that's just come through, Peter, is I have paid all my creditors and staff up to date and still have enough cash to keep my business sustainable for a few months to come. My problem is that the majority of my clients only return on level 2, and because of this clientele, my debtors book is an ICU at this point in time. And then Sandrine asked how are creditors paid, how is the selection process, how does that work? Can a company select which creditor to pay? So I think just if you can marry the two up, they're kind of distinct, Peter, but you can deal with both issues in one answer, considering that we're pretty pressed for time.
Very sure. Creditors have to be treated equally. So if the plan says by class, so if the plan says we're going to pay secured creditors 100 cents in the rand because they have value in their security. So the bank has got a mortgage over the buildings, the plant, the printing plant. We're going to sell that plant to realize that security, maybe do a sale and lease back or sell it out of hand totally, and thereby pay the bank. Remember, their security doesn't disappear because of the freezing and because of the moratorium. So we've got a property that's worth 50 million and the bank's owed 40 million. I sell the property, I pay the bank. I've now got a lease, obviously, so it's important to make sure that whoever you're selling the property to, you're going to be able to continue paying rent if it's currently owned. Or I raise funding against that. There are some people in the distressed market that are particularly interested in properties. And if the printing business in the property is a good cash generator, then it makes an attractive way to do a funding rather than a sale and lease back. But either way, you've got to make sure the practitioner's got to make sure that he can pay. Now, in that scenario, you've paid a secured creditor off in a different method only because of their security. But all creditors in the pot of the unsecured or the concurrent creditors, you have to treat equally. However, if you've got one critical supplier or two critical suppliers, you can do what we call bringing them into the rescue, either treating them as critical to the ongoing business, and they then go to the top of the pile and will be paid out of the proceeds of the rescue as you go. Or even if they just come into the rescue, you can negotiate with them how to settle their debt that was in existence at the date of rescue. This is particularly prevalent where somebody supplied you with stock that they have either reservation of title over, or they have some security over the services that they've provided to you as the printer. You can treat them differently. So yes, creditors can be treated differently in how they paid, but the practitioner is going to exercise extreme caution there, because you don't want one creditor going to court and saying, I've been prejudiced. And certainly if the company then goes into liquidation, there is a possibility of having that transaction overturned as having given what is called in the Insolvency Act undue preference. So that creditor was preferred over another and shouldn't have been. Therefore, we're setting that transaction aside, and the liquidator would go after that, whoever the recipient of that money was, that particular creditor, and ask for that transaction to be reversed. But by and large, creditors are treated equally within the rescue. Sorry, Maurice, what was the other part of the question?
The second question is, I have paid all my creditors and
Sorry.
staff
Okay.
up to date still have. But what I'd like you to do is address the question practically. So what you would do practically as engaged.
Well, as I said earlier on, don't forget, and it's such a critical thing at the moment, cash really is king. So be very cautious. You know, a business thinking, well, I'm all right, I've paid everybody, so I don't owe any money. Just remember that if you don't owe any money, that means owe anybody any money, it means you've got less money in the bank account. And if you're assuming that your customers are going to come out of lockdown in whichever particular level they're affects them, then add a couple of extra months. And if you can see beyond that, and I would argue even a few months beyond that, assume that things are going to come right by the end of September. And if you can manage to keep your company going at that period, it might sound a bit extreme, but remember, coming out of lockdown is not a necessary issue. It's certainly in the printing industry, because why are we seeing Caxton's close down their printing division? Why does the Associated Media that's been in business for 40 years plus, for what reason? Because advertising spend suddenly collapsed. Now, who are the advertisers? The advertisers are the very businesses that are suffering at the moment. So no advertising spend, no magazines going out, close them down. Who does that affect? Obviously the printing industry. So, you know, just be cautious of trying to do good by your suppliers as they stand at the moment, and then end up doing bad by your employees and your suppliers in the future because you suddenly find you're short of cash. So practically, please hang on to your cash. What does that mean? It means either rescue, but if you decided not to go into rescue, it means communicating with your creditors, letting them know you're going to pay them, you know, I don't know, 20% of the amount, asking them or telling them that you're going to have to put them onto 90 days rather than 60 or 30 days, and try and push out your creditors. Try and use your creditors as funders to your business. Obviously, you've got a stronger argument if you're asking them to do that in rescue, because they are preferred if they continue to supply you with services. But negotiation, communication, critical. Same as Marie said on your staff. Trying to get people to take reduced salaries at the moment is far better than paying them their leave pay, as I covered earlier. Does that cover it, Maurice?
Yes, it does. Thanks for that, Peter. I just want to add, just to conclude, because we are out of time. To the question, I've paid all my creditors and staff up to date and still have enough cash to keep my business sustainable. Now, there's certain nuances there. If you paid creditors because you signed personally a suretyship, okay, so let's say a creditor goes after you in terms of the surety, that surety still applies. Peter's mentioned it, but that surety, despite a business rescue, can still be recovered. So if you're going to be settling a debt as a surety, rather put the money into the business as post-commencement finance to get the preference and have the business then pay and settle the debt. The same applies if you're going to pay staff, which a lot of people have been doing. Put it in, don't pay the staff direct, put it in as post-commencement finance, and you'll get preference down the line. So I think that's an important take home. I don't know if there's anything that the panelists would like to add. Final questions?
Maurice, just to, one of the challenges that the printing industry has is obviously the magazine industry. I mean, Caxton have withdrawn from, I think that's about, it's certainly over 10 titles, about 12, 13 titles that Caxton's have there. But also don't forget, Caxton's has a massive printing business in Pol Media. So, all Caxton's local newspapers, community newspapers are coming out of the Pol Media printing stable. Some of them are done up here. So the trick for printers is to find out what other skills you have or what other ability you have in your plant to diversify. I mean, if you just, Caxton's is a well-financed company, but it's in a lot of other businesses to boot. NASPAS, I mean, Media 24, magazine industry, but now here's an interesting thing. Media 24 were still able to deliver You magazine. Why? Because You magazine's been classed as a newspaper, and newspapers were allowed to deliver, whereas magazines weren't. So they suddenly had the edge. And if you think of the magazines that Caxton's had just closed down, some of those have been with us for years. I saw some of the press, they're keeping going, Farmers Weekly and Living. Those are two magazines that clearly are more treated as newspapers than your classic magazines. So see where there's that opportunity, and don't forget the government printing works is still up and running, and the government is still using printers. So if you're not in, you're going to worry about getting paid, but if you're not printing for the government at the moment, then try and find state contracts to print for the government, and try and diversify. We know that people have moved into media. I mean, this is not a new thing. Caxton's, NASPAS, in Media 24, Associated Media knew for ages that people are moving away from magazines and that style of advertising and printing. It's gone electronic. Try and see what you can do in that environment, but be creative. If you've got a small operation and it's fully funded at the moment, I would still be looking at how do I diversify. Specialized printing, embossed printing, which is specialized. People that have gone into that have done well out of it. The Bidvest Group is buying up printing businesses. So if you're looking for a funder, it's not a bad place to go to.
And one more thing, and Maurice touched on it earlier. What we've been preaching since right from the outset is a variable costing model, moving to a variable costing model whereby you link your costs to your turnover. You can do that with landlords now through proper negotiation, which we can assist you. You can do that with staff, as Maurice touched on. Link your cost to turnover. That's the only way companies are going to survive. And whether it's Caxton, whether it's Comair, whether it's SAA, it's all the same. It's an overriding rule that can work. Link your cost to turnover, and then, as Peter said, use initiative to increase turnover. And as you increase turnover, you can rebuild up a business again. But that's a critical, one of the most core messages that we are putting out there to absolutely everybody who we deal with.
And I sort of mentioned, just in conclusion, that two businesses, I highlight the simplicity of a business rescue that engaged were in, and the two business rescues, and they approached the two separately. So the one they approached by looking at pivoting the business, and that involved a Mexican restaurant. And what Engage did there was they went in, looked at the menus, added to the menus, and created a closed environment So they collapsed and moved to the kitchens. So there's a pivot, and then restaurant in Camps Bay. We went to the business rescue practitioner, went to the landlord, negotiated with the landlord because that's all that was required. It was a very, very quick business rescue. It was an in and out. And as soon as the landlord agreed, the plan was approved and it was business as usual. So it can be simple, and it's more often than not, particularly in the present climate, it's the rational way to go. Yeah, so that concludes today. We do have daily webinars. In fact, today we've had several webinars. So there's the Monday webinars, we cover business rescue in general. There are many videos on the COBRA website that you can tap into. You can have private sessions with us if required. We haven't covered everything today, so there's a lot more to cover. So if any of you want us to have a second session to deal with specific topics, we can do that. We're really, really flexible. So I'll ask that you send us an email so that we can assist you guys, info@cobra.co.za. There's absolutely no downside, so think about it. Why wouldn't you? I'd like to thank my panelists.
Info@cobra.org.za, just to correct you, man.
What did I say? Okay.
Yeah, that's
Sorry about that. So, yeah, org.za, very, very important. Same with the website. Yeah, so send us that email. Think about it. Why wouldn't you? Thanks to the panelists. Thanks, everybody. I hope to see some of the attendees at next week's seminars. Thanks, guys.
Thank you.
Cheers.
Thanks, Mark.